that one must be given a date for trial at the next possible trial date. We even ask that the state bring the set-down book to court, but the magistrate says he has no power to do that, which naturally we disagree with, because a section in the CPNA Act is for the court to interpret. So when you get a magistrate who says, I cannot, in fact, tell the state to implement provisions of the law, you ask yourself, so what is the magistrate in court for? Because we are in court because of the Criminal Procedure and Evidence Act. We've become used to being treated like this in all the Sikala cases. You will recall that the other week we were in court at 9. We were told that the matter was before the Deputy Chief Magistrate, who referred us back to Court 14. Court 14 referred us back to the Deputy Chief Magistrate. Deputy Chief Magistrate had to come to court to actually say he is not seized with the matter, and at about 11:30, the matter was given to a different magistrate who was in the middle of a trial. So you can see that the Sikala cases are not being treated in the same way that other cases are, and we as defense team are extremely disrespected, because they don't even phone to say, oh, we have other matters, please come an hour later. So you come to court expecting a ruling at 2:15, and a ruling is only made at 4:15. Trial date is a deliberate ploy to keep him in custody on the basis that, oh, we have already given him a trial date. This is why they are failing to give us the state papers. If the docket is ready and the matter is ready for trial, surely you should give us the state papers. We've asked for the state papers over and over again, even in writing, and they've not been given, because we know that they are not ready with the trial date. And the magistrate is refusing to order them to bring the set-down book to court to show when the next available date is, because he is aware that there is, in fact, no red docket. This is just a deliberate ploy to ensure that being granted bail on the 10, only one night in custody, and the court said, it didn't say that, oh, my ruling will be ready next week. The very same magistrate granted bail on the 10. And yet Zach says we have a watertight case. In our cases, they rely on grounds that we have a very strong case. When the same is said by the state, in other cases, the court disregards that and gives them a bail and the freedom to roam around. So you can see that justice is not even in Zimbabwe. Justice depends entirely on who you are and entirely before which magistrate you appear. It has nothing whatsoever to do with what our statute book says is justice.